If you have a history of cheating on your tax returns, or you have unreported offshore income along with undisclosed offshore accounts, if you are finding it difficult to sleep soundly at night because you have knowledge or merely a nagging feeling that your intentional tax crimes are about to be exposed or could be, listen, tax and foreign information reporting fraud can quickly escalate into criminal tax exposure. It can result in huge penalties, years of litigation followed by potentially incarceration, restitution, and worse yet, deportation if you're here on a green card, especially in today's political environment. If you're even wondering whether you should act, this video is for you. Hi, my name's David W. Klasing. I'm a dual licensed criminal tax defense attorney in CPAs. I've handled hundreds of high-risk audits, criminal tax investigations, and criminal tax prosecutions, and lots of voluntary disclosure cases. I've seen clients who tried to fix it themselves utilizing the wrong type of tax professional that wound up in far worse trouble than they started with. Today I'm going to walk you through how the IRS Voluntary Disclosure Program works, the real risks of waiting, the mistakes people make, and why legal privilege that can't be provided by an accountant or tax preparer is the protection you actually need. Listen, this video isn't about guilt or shame, it's about risk management. The moment a tax authority sees a pattern of intentional taxable income omissions or concealment, they don't just assess tax, they consider at best civil fraud penalties and at worst a criminal tax referral. Most states cooperate with the IRS in identifying and prosecuting tax fraud. You want to remove the risk of being prosecuted for tax crimes. How and when you act matters much more than your underlying history of cheating on your taxes. A state or federal voluntary disclosure is a formal pathway that allows taxpayers to come forward and disclose intentionally unreported tax liabilities. These programs offer a promise to forego criminal tax prosecution. They offer reduced civil penalties and other favorable treatment, but none of this is automatic. There are strict rules about timing, completeness, and cooperation. If you qualify, a voluntary disclosure will reduce or eliminate civil penalties. It will remove exposure for criminal tax referral. If you don't qualify, if you get this process wrong, those protections disappear. Listen, you're at risk for criminal tax prosecution if any of the following are true. You have offshore accounts or foreign income that you didn't report. You use preparers who failed to include foreign disclosures. You claimed aggressive deductions without proper substantiation. You claimed credits that you were not entitled to. You received an inquiry or letter and simply ignored it. The patterns we see are always the same. Intentional misstatements compound. Facing requests for intent-focused explanations when they stack up, and a civil audit turns into a criminal tax investigation. That's when a criminal tax exposure becomes real. You don't want to be there. Voluntary disclosure eliminates all of it. Waiting is the most common mistake. Once a federal or state tax agency suspects willful conduct, concealment, fake transfers, shredded records, the window for favorable voluntary disclosure treatment shrinks or closes completely. If you're under audit, you don't qualify. Evidence fades, documents disappear, and the case becomes adversarial. The longer you wait, the fewer options you'll have to fix these problems without facing criminal tax prosecution. Every voluntary disclosure program is different, but the basic process is this. You must come forward voluntarily. You must disclose completely, and you must cooperate fully in rectifying the non-compliance. That means you produce records, you amend returns, you write checks and pay taxes and the interest owed. In return, you may receive reduced civil penalties, and you will receive protection from criminal tax prosecution. But only if your voluntary disclosure meets the correct criteria. If you involve the wrong tax professionals or you reveal too much at the wrong time, you can lose those protections entirely. Accountants and preparers are essential, but they won't have attorney-client privilege or work product privilege. Matter of fact, it's the unlicensed practice of law for them to put you in one of these programs. That means any conversations you have with them can be compelled in a criminal tax investigation and prosecution. They could be on the witness stand testifying against you. If an accountant is stupid enough to prepare a voluntary disclosure, and that triggers deeper scrutiny, any emails, any drafts, any notes that they prepared, you prepared, that could all be subpoenaed. That's where a dual licensed criminal tax defense attorney and CPA can change everything. Legal privilege protects your communications. It gives you a safe channel to evaluate risk and plan strategy. Listen, an attorney with privilege is critical to this process. Please do not enter into this with anybody else. Attorney can do three things a tax preparer can't. They can shield your communications and strategy with privilege. They can negotiate directly with authorities on legal grounds, including those surrounding your intent and your culpability. They can coordinate a multi-jurisdictional defense, state, federal, even international. If the goal is real here, an enforceable resolution that minimizes civil exposure and eliminates criminal tax exposure, that legal layer of having an attorney involved isn't optional, it's essential. If you act early and correctly, the voluntary disclosure can save you hundreds of thousands of dollars in penalties and entirely avoid criminal tax referral and prosecution. If you wait, your risk of a long criminal tax investigation, higher civil penalties, and the very real risk of criminal tax prosecution is still there. Listen, some cases close in months, others take years. It really depends on the complexity and what's at stake. The biggest mistakes we see people make here, trying to reconstruct records without legal guidance, letting non-privileged consultants draft disclosures, oversharing with the taxing authorities before a strategy is even set, assuming an accountant's fee covers legal protection. These type of errors can turn what should be a purely civil issue into a full-blown legal battle. When we take a voluntary disclosure case, we start by securing privilege. We gather the facts, and we perform a legal risk assessment. We reconstruct the client's tax position. We identify qualifying factors and present the disclosure to maximize protection. If litigation risks arise, we build a defense around intent, documentation, and cooperation. Our process is designed to ensure that there are no surprises. If you have unreported income, offshore income, foreign accounts that didn't disclose, or you're just simply unsure about past tax filings, don't guess. A single wrong move can cost you everything. If this applies to you, take one step. Please talk to a dual licensed criminal tax defense attorney and CPA. If not us, someone like us. Make sure they intimately understand voluntary disclosures and privilege. Getting legal counsel early is the difference between resolving things quietly and winding up pleading guilty in a criminal tax court. It's that serious.